Hey folks, tonight I wanted to come to you and I wanted to talk about the steps in selling items by probate or going through probate as far as that's concerned. Um, I met a real nice lady down at the probate office and she says, "What are you doing here?" And I was like, "Well, I'm doing the paperwork for an estate and I've gotten one who wants me to help them with an estate, and I also have somebody who wants me to be their executor, which I'm honored to do. Uh, we just have to work out a couple of the details as far as that's concerned, which is good. I mean, we're having negotiations back and forth, and I send him memes, he sends me memes, which is great. So, what is probate? Probate is the popular belief that something is in and out as handling everybody's stuff after they pass away. Uh, I wrote a couple of articles about the universal problem of stuff that we have. And a lot of people will say, well, I'm a real estate broker. The only thing that I just tell the people to do is just throw the stuff away and then I go and sell the house. Well, that's violating your fiduciary duties and agency to the family and to the executor if you're telling them to throw away uh, their personal property just so you can sell the house. I think it's kind of selfish. But what is probate? Probate is it's either the administration of the will, and if that's the case, then you're called an executor or an executrix. If you are going to be appointed an administrator, that means that there was no will, and you could be an administratrix uh, as far as that's concerned. So you would be a person who would be responsible for collecting all the information and whatnot, and then getting it forward to um, the clerk of court. So some of the courts have a goldenrod sheet, and the goldenrod sheet is going to say these are what the beginning instructions are. And the beginning instructions will be to something to the effect of you're creating an application for the administration of the will, and that would be any of the, it could be testate or intestate. And if it's intestate, of course, there's no will. So, if there's nobody after 90 days that says, I want to do this with the will, then somebody can come in and say, well, I'll go ahead and do it. I'll go hunt it down so we can get this closed out. Now, if you do those letters for administration, you will have the opportunity to present the will, which is one of these. And the will say a couple of things: who they want to be the executor or executrix, and it will also say what to do with all their personal property, and it will also say something to the effect of what they want done with any of their intellectual property, etc. Sometimes it's not as clear as to what they want, so the administrator or the executor is going to have to come up with the solution for it. And then once that is taken care of, I got this handy dandy stack of paper. Once that's taken care of, and once the application goes through, then they will make the decision whether or not you need to be bonded. And the bond is basically just an insurance policy to ensure that anything that is done with the monies and whatnot is actually shows flow through. So, say for instance, if I'm the administrator of an estate and there's $10,000 in it, there's $10,000 coming in, there's $10,000 that are divided and going amongst the heirs minus expenses. That's basically what we do. The next steps after that is that you have to put in the newspaper for 90 days a item that says having qualified as the administrator or the executor, anybody who owes any money needs to pay it immediately to this address by this date, or any kind of debts, or be forever barred. Period. Once, if they have any kind of complaint against the estate, if they don't produce it within those 90 days, then after that last day, they're stuck with it, which means anybody who has, repair fee or any of that other stuff, So you have to ensure that it runs for the 90 days. And once the 90 days are over, then you can go back and do other things. Then, after you go ahead and get approved, there's 90 days for you to uh, take an inventory of all the assets. Now, the assets are going to be, I have to put my glasses on because they're listed all the way over here. Accounts of the sole that has the sole descendant on it, which is if they're settlements, or if you go to NC Cash or anything like that and they're in their name, that also includes all of those accounts, banks, account numbers, and the balances that are in there, if you can get the balances. But you have to present them with the death certificates. You have to present them with the letters of testamentary. And this is an active case that I'm doing right now. So I'm showing you the paperwork as we're going down the road. Then any joints accounts without right of survivorship. So this is going to be joint accounts that say Matt and Frank Capra, okay? And the without survivorship means that, we survivorship, if I pass away, then Frank Capra gets the rest of it, right? So it goes to a percentage owned type of thing. So 50%, 50%. And this is where a lot of real estate and estate attorneys get in trouble, because the so-called estate attorneys will say, well, you know what? Since you're the executor, you are the sole owner and you're the sole responsible party to liquidate the real estate. Well, that's not how it works in North Carolina. If somebody passes away and it's in the will that says, I will this to X in order for them to sell it, that's one thing. But if it is, I give them the authorization to sell it, it is still owned as tenants in common, and they have an equal split. So say, for instance, if you have a property that's worth $100,000, and there is the water bill, the electric bill, and the taxes, and the trash pickup, and everything else about that, then that bill gets split between all four of you in four ways. If it gets willed into the estate, then the estate's responsible for all of those. But if it gets willed individually, or the individual power of attorney gets that, then all of those costs get absorbed by all four of the heirs. And attorneys really get ticked off at me because I point this out to them, because they're just like, well, this is not how we do it. And it's like, well, we call that malpractice. Yeah. So anyway, continuing on down. Joints with accounts is if I have $1 and Frank has $1 and we put it in this account, then we both own 50% of it. And if we close out that account, then you get 50% of it. And if then my heirs, my estate will get 50%, and then Frank Capra will get the other 50%. So he'll get his $1 back, and then my estate will get the $1. Stocks and bonds in the sole name of the descendant or jointly owned without right of survivorship. Basically the same thing. If there's not a there's insurance policies that are not jointly owned, then there is a 25, 25, 25, 25 for, if, say, for instance, if there's four heirs or beneficiaries. Cash and undeposited checks on hand. That is, if you go squirreling around in any single one of these estates, you're going to find cash. History has proven time and time again that when we take a look at going into any of these places in order to sell the personal property, we are going to find cash in places that people would not even imagine, such as behind pictures and pockets hanging in the window, in the closets, taped underneath dresser drawers, underneath beds. There'd be little holes ripped into the foundations where money is stored. Any of that, you will find money in an estate like you would not believe. Some of it could be, from past Depression era belief that you have to stash money in order to keep it. Uh, and there might be even some undeposited checks, such as you come in and you see that there's a check sitting there that was written out for the power company, and well, you go and you mail it because that's what they were going to pay it. You go ahead and mail it. Well, then you turn around and then you have to put that in your inventory. Any undeposited checks, any cash that's found, even if you found a quarter in the sofa seats, you have to record it. I'm being a little bit facetious, but if it's $25,000 in the couch, you best record it. On top of that, you're talking about any other personal property such as vehicles, household furnishings, farm products, equipment, and tools. That includes anything that might be so much as a wrench, a screwdriver, or anything else like that. You don't have to put it in there piece by piece. You should put it in there as tools, etc. And the reason is because the state wants to make sure that there's not somebody going in there and stealing $100,000 worth of stuff and then leaving the heirs high and dry when they should be getting also a split of that as well. Real estate will to the estate, directed to the will to be sold and sold. That is going to be an individual piece where, so say for instance, last will and testament says that I authorize this person to sell the property. That's not a directive. That is an authorization to sell it, but it's not a directive. The directive is that once they're sworn in as the executor, then they are to sell the property. That is a directive. Authorization and directive are two different things, and a lot of people get those confused. And sometimes I will see real estate brokers who get caught up into the lawsuits only because they see that, oh, well, you're directed, and it says we authorize. Well, two different things, and only person who can wiggle that out is going to be the attorney. So real estate will to the estate. Once it's willed to the estate, the executor has 100% control over it. Directed to be sold in the will, such as it shall go into, or the executor shall sell the real estate and divide the proceeds accordingly. And sold any of the real estate, and it will also ask for an attachment and if there was any kind of proceeds for the particular property. Then, if there was real estate that was willed to the estate and not sold, then they also want to know that. And the reason is because once again they want to make sure that everything is public record as to what was there. So if there's any lawsuit or anything like that, they pull this inventory out, and the executor will get in trouble if it's like, well, according to this, there was no real estate whatsoever, and as far as this is concerned. Joint accounts with right of survivorship. Now, people get a lot pissed off about this, pardon my French, and that is because I will put on an account that that my name, my wife's name, and then with joint survivorship to our grandson, or joint survivorship to somebody else, or joint survivorship, it doesn't matter. Once I pass away, then it will either go to my wife, or if she's passed away and I'm still around, then it will go to whoever that joint survivorship is automatically. And there is nothing that the estate or any of the heirs can do about it. They can say that, oh, well, you faked their signature. You did all this, you did all that. I hate to tell you, but some of these things were written back in 1990 when some of us were still 10 years old. So you explain to us how we managed to coerce them in order to be an executor when chances are we didn't even know what an executor was, right? So we have to understand that some of these things are set to protect some people, some of these are to protect other people, and some of these are just to cut other people completely out. And that's why this joint accounts with right of survivorship is here is because the state wants to know just in case they go nuts. In some cases, I have been sneakily told, I don't know if it's a sneaky type thing, by the clerk of court that if it were me, I would not include those into this inventory because it's automatically transferred and there's nothing that anybody can do about it. We can't, the clerk of court can't do anything about it. So it's all of that. So stocks, bonds, securities jointly owned with the right of survivorship, which, if you've got stocks, bonds, or some kind of account and it says if I pass away, then it goes to my wife, and if she passed away, then it goes to somebody else. So, and it's going to want to know the stock information so it can be, they can be called up and say, hey, this person passed away, now it transfers over to this person. Other personal property recoverable, this is going to be anything that has been leased out, liened out, borrowed. The next door neighbor has a lawnmower or something else like that. If it can be recovered, it can be recovered. Somebody's borrowing a car. You call 1-800 you call 1-800-MIC-TOW and they drag that sucker back. Whether or not they're using it is irrelevant. If they've destroyed it, it's irrelevant. If they bring it back, it's recovered. Real estate except entirety's property. And basically what that is that includes anything that they may have owned. It includes any partial life estates. They may have an interest in it. Legal descriptions or anything else like that you put into this documentation, and then it all goes to the state of North Carolina in order for them to then process it. And then once they process this, then it's taxed accordingly. It's called an estate tax. And yes, everybody has to pay for it, whether it's testate or intestate. That's why it's important to talk to your attorney about particular trusts that help you avoid those particular taxes. The other thing that you have to do as well, and some people say, no, you don't have to do it. Others say that you do have to do it, is you have to go talk to the Internal Revenue Service about getting an EIN number, and then you have to go talk to your bank about setting up a account for all of the money to go into that account. One thing I did forget is that there is a notice. Where to go? Notice. Affidavit notice to creditors. These are all of the people. You have to put those into the newspaper, and you also have to send this to the creditors. And I'm not aware. Some creditors you're just not aware of. You just have to, go through the bills. And a lot of people, what they do is they shovel the bills into the can, and then you don't ever know about. You don't know anything about it until you close it out, and all of a sudden there's a thing that goes ding, and C-Cash says that you've got money. Okay. So after that, you're free to, one, hire a personal property appraiser or a personal property auctioneer or an estate tag sale company. And one of the first things that you have to ask them is if they will do a full inventory of everything of inside the property. And the reason why the full inventory is important is because of what I just went through. The state wants to know what's there so then they can make sure that it's, one, distributed evenly, two, it's distributed properly, and three, it's taxed appropriately. This all has to be done in 90 days. Not only that, but after you have asked the estate company to do that, you also have to ask somebody else to do it. And my recommendation is to get 3 companies to come in and say, yes, we do a full inventory, or no, we only inventory those things that we sell, or we inventory the things that we sell, but we also inventory the stuff that we don't sell, and then we give you the opportunity to decide what you want to do with it, which is great, because then the executor is the one that makes all the decisions, and you're not relying on somebody coming to you after you've already blown a gasket, trying to explain why they threw away certain things. There are certain things that are marketable. There are certain things that is not marketable. So an estate tag sale, for instance, will come in, a company will come in, and they will go and they will take stuff out that is not marketable, and they'll throw it in the trash. That's great, but it has to be inventoried. Now, not only that, but any insurance documents or anything else like that, sometimes they'll throw them away, not thinking that, oh, well, you know what, they're useless. My mother had a insurance plan that my grandparents created for her going back to 1939. And I had to chase around the insurance company because the insurance companies were bought out about 5 times before I found the insurance company that still had the policy. And believe you me, everybody says, oh, well, this is golden. They only put maybe I think it was up to $75 into it at one point in time. It netted 6,000. Right. So that's the savings rate going on for 70 years. But the thing about it is that you want to ensure that everything is inventoried, and any personal documents such as those insurance policies and whatnot are given to you so they can be properly inventoried, be properly looked up, be properly, you pick up the phone and say, is this insurance policy still valid? And if it is, here's the death certificate and here's the letters of testamentary, and you roll forward with that. A suitable auctioneer and a suitable estate tag sale company will know this. And if they don't know this, then I would suggest that you find another estate tag sale company. And the reason is because while they may not know it, it may turn out that it costs you some more money at the courthouse, because now you're being sued because you threw away, it could have been $1,000 or $2,000. This is how important it is. I have seen real estate brokers come in, call a junk hauling service out, clean out the entire house, clean out the entire attic, and then I get a phone call from the junk hauling service wanting to know if I'm available to go down around the corner and take a look at something. And I went down around the corner and there was $35,000 in a lane chest that had a false bottom. So, yes, the real estate broker was wrong for doing that. And 2, that was $35,000 that was getting ready to go into the dump. You never, ever, ever just want to hoe out something because there is money somewhere. It's either in personal property, or it is in cash, or it is in gold, or it is in silver. It just creates a problem. So that is the paperwork that you need. And then once you actually have completed all of the hoop jumping and everything else, then they will issue you the letters of administration. Once you have those letters of administration, your next priority is to set up a plan. And that plan will be to find any of the estate companies, find any of the auction companies, find any of the auto brokers, find any of the information about the insurance policies, retirement plans, 401ks, all of that. The other thing you need to do is understand that real estate brokers will come in and sometimes they will say, oh, well, here is the listing package. Go ahead and sign it, Mr. Seller, Mrs. Seller. Well, the important thing to understand is Mr. and Mrs. Seller may not be the authorized one to sell the property. Sometimes what they will do is Sue, who is upset because her mother had passed away, don't want anybody else to have any kind of money for the estate. So what she will do is she will go and sign the paperwork to list the property. And of course, in this market, within 3 days, it's sold, and now it's going through all that other stuff. If it doesn't have this paperwork that goes with it, then the signature is invalid on that listing contract, and the real estate broker should be reported to the North Carolina Real Estate Commission. So after you make the plan, you want to set up a date. So normally, probate takes anywhere from 6 months to 12 months. And if you have people who don't want to work with you, especially heirs and beneficiaries, then it will take 6 months to 10 years. And by the 10 to 10 year mark rolls around, you will have squatters in the house. You will have a house that has fallen in because of the lack of maintenance. You have spent all of the money on taxes and utilities and plumbing and water and everything else. You will also have problems as far as trying to resell it. Now, a perfect example, I had a probate case where if they would have sold it 6 months after she passed away, their mother passed away, it would have been worth $250,000. But now we are on year number 9. House has been broken into, the water's been disconnected, the power's been disconnected, barns have fallen down, all of that other stuff. So now all of a sudden we are talking about land value because the roof collapsed in and everything else. So now you're talking about going from $250,000 to the price of the land, which was $53,000. It's pretty sick, but you know, people who are selfish will wind up shooting themselves in the foot. So if you want to find a real estate broker, that's fine, but find ones that understand that the personal property is outside of their wheelhouse, and the only thing that they should be saying is, I would recommend that you find an estate tag sale company or an auctioneer in order to sell everything inside of the property before we even get to the point where we can list or do anything else like that. You also want to ensure that your real estate broker knows the entire process, soup to nuts. And not only that, but with estate sales, auctioneers, and real estate brokers, if they have never, ever, ever touched estates at all, ever, it's best for you to seek out a certified estate specialist such as myself. I will help them get over the humps and understand what their responsibilities are. One of the things that I don't like is when real estate brokers will tell me that a piece of property is worth $4,000 and it's an old Victorian brown wood art easel, which I couldn't sell for $50 on an open market anywhere. So you have to also understand that some real estate brokers will try to overprice it to, do puffery in order to show that, oh, well, I know how much it's worth. They don't know squat as far as personal property is concerned, because we sit here on a regular day basis and we're listing stuff on our bidding platforms. We're doing, $100 bid now, 100 and a quarter now, half, 75, 5, 75. We are constantly doing this, and we know what the values are going for up in here. We have a full catalog of everything. And then we want to set up a timeline. And that timeline is going to be dependent on how long it's going to take for the other 3 items to happen. So usually it takes about 3 weeks to clean out the property. Then there's a week and a half or 2 or 3 maybe in there that's needed for any kind of repairs that you may want to do. And if you are just absolutely, just about, you have to get rid of it, there's 3 ways we can do this. 4 ways, actually. 1, we can price it so it's a little bit higher than what the market price is going for. 2, we can market it right at the going rate, not 2022 rates. We're talking about maybe about 10% below that. And then we're also talking about maybe pricing it below that to try to get a fast sale. However, a fast sale is not necessarily going to be the best sale. I will still say to this day an auction method of marketing is going to be the best way of doing it. And the reason is because you set a date. That sucker is going to sell whether they like it or not. You can set a reserve on it. You don't sell it for pennies on the dollar, and it's not the last ditch effort, but it tells everybody that they're going to have to come to the table with the cash, or they're going to have to come to the table with the financing in order to complete the transaction in less than 20 days, 21 days. It's up to you. The executor is completely in charge, not the real estate broker and not the buyer's agent. They have to do all of their stuff before, such as their inspections. They go do title searches, their permits and whatnot. And then we go to auction day and we crack it open. We close it. We sign the documents right there, and within 21 days they show up at the closing attorney's office with a check to completely close out the sale. So a lot of people will tell you, oh, you don't want to do that because you got to take cash, you got to do this. You got to take a deposit because we need to make sure that you're serious about buying the property. I've done an entire thing on real estate brokers to educate them, and only 3 people have seen it, which tells me that they don't particularly care about offering or representing any buyers at those particular things, which is pretty sad because they're supposed to have a fiduciary duty to you and not to their pocketbook. Now we also have to have a discussion, because we're talking about methods of sale. We're also going to have a discussion about property inspections and appraisals. The property inspections are going to be what you need to fix. Okay, so that might be that you might have a well pump or something like that needs to be replaced. You might need paint. You might need, new carpeting, something like that. The property inspection is going to tell you what is important, which is something that you have to take action on, because what is important is technically a material fact, such as the air conditioner don't work, the water heater exploded, the roof is 35 years old and it started to leak, those kind of things. And that's a number one reason why you want to have these inspections. And you want to have these inspections sooner than later, because if you have a property that's sitting out there for 10 years and you have mold and mildew and whatnot that has infiltrated because of broken windows or a leaky roof or something like that, then that hurts the estate's bottom line. Then the appraisal, say for instance somebody is going to come to you with a cash offer. The appraisal is going to come in and they're going to be able to hand you an offer right then and there. And that offer, when they actually go and do it, they're going to want to appraise it to make sure that what they're paying for is what they're going to be getting in value. So if you have 4 acres of land and you're going to sell it for $40,000, well, they kind of sort of want to have an appraisal. They want a soil and water scientist to go out there and tell them, what kind of acreage are we looking for, what's going to be available, what's actually buildable, etc. They might even just use it for planting and stuff, but they want to make sure that what they have is actually usable. So the appraisal is going to tell you and them how much it's worth, and they may adjust their price accordingly. Now, if they come in and say, for instance, it's a $130,000 property and they offer you $20,000 for it, well, they'll come in at $100,000 and then they go and have an appraisal done, and then they'll have the inspections done, and then they'll come back with a $20,000 correction. But you can always say no, because that will kill the deal right then and there. So the other thing too is that you want to budget inside of that any cleaning and repairs. And I mean, you've got light switches and stuff like that get cracked and whatnot, but you also have leaky faucets, maybe a couple of pipes that need to be replaced, etc. You might have some exterior things that may need to be replaced or fixed or something to that effect. But we, as real estate brokers, auctioneers, estate sale professionals, we have a list of people in our quiver who can come in within a couple of weeks to take care of that. Now, sometimes it may take longer than a couple of weeks. Sometimes it might be that because of they're so backed up that it might take it might take 3 or 4 weeks instead of 1 or 2, and that's understandable. The important thing about this is that you can have a couple of ways of doing this. One is you can list it with warranties. You can list it without warranties. You can list it with uh, as is, as you see it. However, the thing about it is that you and possibly your co-executors have to know information about the particular property and have those documented. So not only are you on the hook to sell the property, but you also have to have some kind of working understanding as to what's available, what's not, what's working, what's not. And those are North Carolina real estate disclosure documents that everybody has to fill out whether they want to or not. Unfortunately, it's a requirement. And then if you find out that the washing machine, you check mark saying, yeah, it's okay, it works, and you find out that the washing machine has a bad coil in it, so now it doesn't do anything, then you have to go back and redo those. Same with oil and mineral rights. You may have 4 acres of land and you have lived there your entire life, but your parents may have sold off the oil and mineral rights because they needed to send one of you guys through college, or they needed to do uh, an update to a piece of property, or they needed to go out and have the well pump fixed. You won't know that until a title search is actually done. You also want to ensure that if you have a Medicare or Medicaid lien against the property, that you have taken ample amount of time to jump on that to make sure that you're getting the absolute top dollar for everything that's in the house. So you may think that it's an inconvenience to throw away everything in the house, but the house sells for maybe $100,000 and you have a $120,000 lien against it. There's a $120,000 Medicaid lien against it. Well, you got to think, was there $20,000 worth of personal property in there that could pay off the lien so everything else is free and clear? That's why it's important to call in people who are estate sales specialists and auctioneers and real estate brokers who can give you the full 45-day, full 90-day experience, and then that way you're maximizing the return back into the estate versus all of a sudden the heirs needing to throw money into the estate because of any kind of liens. And not only that, but you also have to take a look at any kind of liens that may be because of workmanship or any of that other stuff that may come through. Now, the other thing too is that may hang you up is it might be co-executors that hang you up. It might be beneficiaries that think that they're getting a raw deal because you're putting up you had an auction and the personal property only brought $25,000. Believe you me, if it brought $25,000, you're doing outstandingly well. But if you're saying that if it didn't bring $25,000 or it only brought $25,000 and you think it's worth 50, that's not a concern for an auctioneer or an estate tag sale person. And the reason is because the market decides how much the value is of anything, not individuals' opinions. Grandma's yellow pie plate, you may think it's worth $1 million. That's all fine and dandy, but in the real market, it's worth 5. You send it to a thrift store thinking that the thrift store is going to get, a fairly handsome return on the value. Well, they get $5 for it. Who's right? So understand that when things are priced in an estate tag sale, it's not priced on sentimental value, it's priced on market value. The same thing with your house. You may think that you have, $1.5 million worth of real estate on a 30-acre farm with, the old rundown house and everything's been out of sorts for 10 years and, nothing's been managed. Well, that's really easy. A 30-acre $1 million farm is a 30-acre $1 million farm at the time of death, but as it sits there and it degrades, it goes from $1 million to $800,000. It could really be easy to just go ahead and get to the point where it's only worth $30,000, and that's because of the land value at $1,000 an acre. So it's important that everybody be on the same page. And I attempt to be completely transparent with everybody. And some people can't stomach it. They need some Rolaids or Tums or something like that, which is fine. But I'm not going to sugarcoat anything, because in these particular situations, you're having to deal with not only the heirs of the estate or the executors of the estate, but you're also having to deal with the state of North Carolina and the clerk of court and the judge. So you want to ensure that you are being up and up with everything having to deal with the estate, and you want to make sure that you're doing everything possible to ensure that everything is done correctly. Now, there was just one more thing that I wanted to tell you about, and that is part of doing the search for anything having to do with. There's some letters that I have. Part of what you have to do is you have to go and research and research and research and bump your head and then research again. Well, you also don't want to forget to go take a look at NC Cash. Because NC Cash will have money out there that even whoever passed away didn't know that they were owed, and then when they attempted to get in touch with them, it didn't go well. And when I mean it didn't go well, nobody knew how to get in hold of them, so it went straight up to North Carolina. So that being said, I just wanted to go over that is basically the step-by-step for North Carolina. Then once all of this is done, all the chaos and all the hectics and all the people complaining and everything else is done, then there's a final accounting that is done for the estate. And if you get a attorney that is it's their first rodeo, you're never going to get it closed, because they're there. I'll just say this. There's not an attorney on this planet that does not do stupid stuff in order to pad their bank account. A perfect example is we had somebody who did not understand property rights, so they turned around and sued the estate. Well, the judge ruled against the attorney, because the attorney didn't have a clue that all four owned it, but they sued the executor for $500,000. And guess who lost? The people who sued them, because the attorney was basically did not understand what was going on. Didn't understand about property rights in North Carolina. So, anywho, is an attorney good? Yes. Qualify them. Ask them questions. Ask them in-depth questions. In-depth questions. Those questions are, so if I have a house and they've died without a will, and there's 6 of us, who gets the house? And their answer should be, it belongs to all 6 of you. Equally, you can't throw somebody off the island because you don't think that they deserve to be there or any of that other mess. All 6 of you own it. All 6 of you are responsible for the power, water, lights, utilities, maintenance, taxes, you name it. All of it. So you have to be sure of that. And then another question you can ask them is, I have a house, there's 6 of us. The will says it has to go over to Fannie Mae, and Fannie Mae is supposed to sell it. Well, what is their response? It should be, Fannie Mae has to be the listing person for that particular property. Then she sells it, and then she disperses it according to the will. So you're going to get different answers, but those are the common flubs that I see attorneys make, and it causes more time in court, because what they're saying is not necessarily going with the estate law in North Carolina. I'm not saying that all of them are bad. I'm saying that all of them have specialties, and they will say that I do criminal law in estates. Stay away from them. They do criminal law. They don't do estates, because estates are just a small amount, so they don't stay up to date with it. Whereas me, I stay up to date with my certified estate specialist stuff with continuing education that goes on and on and on and on, and new laws, new rules, new methods of doing everything. Well, that's everything, I think. And if I forgot something, we'll do a follow up. But anyway, I'm Matt Price. I am your certified estate specialist, your real estate broker, auctioneer, estate tax specialist. Have a fantastic day. I will see you again.